Hello and welcome to the practical side. This is a show where we discuss the practical side of law with different experts on different aspects of law. Joining me today is a special guest, Advocate Nitin Prasad. Nitin Prasad is joining us to discuss about the Commercial Courts Act. First, let us welcome him. Hello, Nitin.
Yeah, hi, Alok.
Yeah, nice to have you here, Nitin. So,
Yeah,
Nitin
thanks.
is a practicing advocate. He's a partner at King and Partridge. He's based out of Bangalore, and he has experience about 12 years. And he's one of the early advocates who started practice in the Commercial Courts Act. So, Nitin, here our audience is primarily students who are studying the company secretary course, and there are also quite a few of them who are doing law with CS. So, when we talk about the Commercial Courts Act, can you please tell us a little history, as in why was this act even required? Because this is relatively new. Just in 2015, this was enacted. Could you please share that with us?
Yeah, see, the reasons why the act came into force or was, thought about and legislated is, very evident from the objects and reasons of the act, which is quite comprehensive. But, to put it in a nutshell, I think the Parliament, through the Law Commission, they in fact referred to the report of the Commission. I think it was the 253rd Law Commission report, which in fact recommended strongly that commercial courts be established, not only on the district level, but also at the High Court level, which is called commercial appellate divisions and whatever.
Okay.
That we won't go into that. But the basic intention behind it was to see that these, of course, the objects and reasons call them high value, commercial disputes, to see that there is a separate and special mechanism, dedicated mechanism to adjudicate on these disputes. And the Law Commission and of course consequently the Parliament, they thought it fit to have these because these commercial disputes, have their own complications, and the commercial side of it also has to be understood by the judge while adjudicating these disputes. That was the only
So,
and to
with
provide, of course, a speedy, resolution of
speedy
these
justice.
disputes, which is
Yeah.
what any commercial, man or any company or whoever, they don't want to be, languishing in court for too long. So,
True.
yeah, that's the
So,
bit.
what was the jurisdiction before this act came? As in the matters which are falling under the act now, where did the aggrieved parties had to go before this act was there?
See, before this act came into force, it was the ordinary civil court based on pecuniary jurisdiction, and territorial jurisdiction. The parties had to approach. So, under Section 9 of the Code of Civil Procedure, I think some of them will know that the jurisdiction of an ordinary civil court is very wide. So it basically covers all types of cases, unless or excepting those which are specifically barred. So any person aggrieved, or having a claim against another, be it a money claim or a property dispute or whatever it may be, or arising under a joint development agreement or whatever, would have to go to the civil court, or if they had an arbitration agreement, go to the arbitrator. So that was those were the only two avenues available before the Commercial Courts Act came. So,
Great. So now that we got to know a little bit about the history and the law commission which you shared with us, in this act, what is the jurisdiction or what kind of matters? Can you please tell both the pecuniary and territorial?
see, territorial, of course, the situation as it prevailed before the Act came into force still holds good. So, for any civil dispute, the jurisdiction of the court would be, where the cause of action arose or where the defendant resides. So, either one of those, or where the subject matter of the suit is, based. So that still continues like it did in an ordinary civil matter. But so far as the subject matter of cases which would go before a commercial court, that is under Section 2C of the Commercial Courts Act. So there are various types of transactions which are covered, which includes joint venture and general commercial supply and you know manufacture and supply, partnerships, partnership disputes also go there, IP disputes. So there are various dispute there. This section 2C is quite wide. So the practical aspect of it is, I'll just give you an example now in Bangalore. There are I think about 89 or 90 courts, district courts headed by district judges in Bangalore for Bangalore urban. Out of those, up until about a month ago, there were only 2 commercial courts in Bangalore. And the rest of them were ordinary courts.
Okay.
That is, there were 84 courts or so. Okay. Now they've established a few more, and now there are totally 90.
Okay.
And I think only about 8 or 9 are commercial courts. Rest of them are ordinary city civil courts. So now with the definition of a commercial dispute under section 2C being as wide as it is, most matters end up going to the commercial court. So you have essentially, about 60 to 70% of the disputes being handled by roughly 10% of the number of judges.
Okay.
So that's what is happening now. So we are in that transition phase where eventually I'm sure the government and the High Court will recognize that every other dispute is a commercial dispute, and therefore they'll need to set up more commercial courts. And the other aspect is you've not yet come to that. We've not yet come to that. In
No,
2018,
actually, you were telling about high value transactions.
yes.
So, like, is there a number to it? Like, how does it work?
The Act as it stood before the 2018 amendment provided only for disputes, where the claim principal plus interest was 1 crore or above.
Okay.
So that time there were not so many. The need for courts was lesser, and the number of disputes, of course, was lesser. So now with the 2018 amendment, the specified value, as it's called in the Act, has been brought down from 1 crore to 3 lakhs.
Okay.
So in Bangalore, I don't think there are too many cases going before the civil court where the value is less than 3 lakhs.
Yes.
So every case goes there. So that is so far as money cases are concerned. And like I said, every commercial transaction, if you see the definition, it's quite wide. All kinds of disputes arising out of various types of agreements and IP and insurance, contracts of agency, and everything, virtually every case except for an ordinary, let's say, a property based injunction suit or a partition suit. I don't see too many other cases remaining with the civil courts.
So this is the future. Everything, practically everything under the sun, which is of commercial nature, comes under the Commercial Courts Act.
Yes,
We can say that.
Yeah.
Okay. So here, since you have been practicing, could you please help with some of the practical examples, are in the kind of matters, basically, the kind of matters which get referred. If you could share a few, I think that will throw some light for the students.
Yeah. See, there are two things. Now, till some time ago, we were in a stage of transition. So the Commercial Courts Act itself provided under Section 15 for all these commercial disputes being transferred to the commercial courts. So that situation has now stopped. Now, any party who wishes to file a commercial suit needs to directly file it before the commercial court. If he wrongly files it before the civil court, his plaint will be returned and he will have to represent it before the commercial court, because it's in essence a question of jurisdiction.
Yeah.
The jurisdictions are entirely different now. So, the most common sort of matter which you will find in a commercial court is probably a money recovery suit. A simple money recovery suit where the plaintiff, say, has manufactured and supplied or just supplied or sold any goods, any products to the defendant, and the defendant has failed to pay. So those things would come within the ambit of a commercial court. And joint developments. There are in Bangalore, that's quite common for these landowners to enter into joint development agreements. and the builder may default, or the owner may default in some way, or the owner may have a claim against the builder for damages on account of delay in performing his obligation. So those, of course, he will have to initiate a commercial dispute. All this is assuming that the joint development agreement does not have an arbitration clause. I am proceeding on that basis. And there are various kinds of agreements: franchising, distribution and licensing, management and consultancy, joint venture, shareholders agreements, partnership agreement. So even we recently did a matter, of course, that ended in an arbitral award. But that arbitral award, we had to challenge before a commercial court because the nature of the dispute was commercial. So even I'll come to that later. Even matters which arise out of arbitration or in connection with arbitration, if they are commercial in nature, they will have to go to the commercial court, either under Section 9 or 34 if you're wanting to challenge the award. Then what else? So this term, there is one term that is 2C clause 11 of the provision, which refers to joint venture agreements.
Yes.
So in fact, we had an interesting situation now. It still matters going on. The question there is whether the commercial court is the only court of jurisdiction, or the civil court also would have jurisdiction in that matter. There, of course, the lands involved, most of them are agricultural lands. And the parties, the owners and the builder, have entered into an agreement, a preliminary agreement, whereunder the owner will make available all these lands to the builder for development, and a joint development agreement and sharing and all that will be done later.
Okay.
So there the question is whether such a dispute would come within the ambit of the commercial court. So our take on that matter is that the term joint venture is quite wide.
Yes.
So it need not, need not arise out of a joint development agreement per se. Here are two parties, with only commercial intentions, entering into a sort of a joint venture, loosely worded, it is a joint venture to work together later, collaborate and, develop the land and for profit. So the intention is commercial and it fits into the term joint venture.
Okay.
So those are the kind, and there are still a lot of matters where, the courts are not sure, the parties are not sure, whether, some peculiar cases may not fit exactly into the definition of a commercial dispute under the Act. So these are some of the examples I can give you straight away.
Okay. So what about matters relating to companies, the dispute between shareholders, for instance, or like you were mentioning, shareholders agreement. So how often do these kind of disputes get referred?
No, see, insofar as a company is concerned, if there is a dispute between a company and a shareholder, because there the NCLT's jurisdiction will come.
Correct.
He may not be entitled to file a suit unless, for some action of the company, he has suffered some loss as a shareholder, and therefore he may be able to maintain a suit for damages. But if he is, pursuing or prosecuting his right as a shareholder, as against the company, then of course the forum may be the NCLT, depending on the situation in that case. But he can approach, definitely he can approach if there is any element of a commercial transaction.
Okay, great. So now coming to the next thing is the evidence. So does it work just like the High Court, or like how does it work in the commercial courts?
See, the procedure is somewhat different, but once the evidence starts, once the examination in chief of the plaintiff witness starts, it is more or less the same. There is really no marked distinction. But one departure is, it starts from, in fact, filing of the plaint itself. In a commercial suit, as against a regular civil suit, you don't have to, the plaintiff is not required to file originals or certified copies of the documents he is relying on. Photocopies are sufficient. So that is a departure from the procedure in a regular civil suit. And then once the issues are framed and, after the defendant comes on record and files his written statement, issues are framed. After that, the matter is posted for, inspection of documents and for the parties to file their respective affidavits on admission and denial of documents. So this system is a complete departure from what it was
Okay.
in, before this act came into force. So, it cuts down the need for evidence, oral evidence, and, in essence, any of these commercial disputes is mostly based on records.
Records and
There is not
documents.
much, yes, because in a company, you can't attribute personal knowledge to anybody. Any
Yes.
witness who comes deposes on the basis of records. So once the parties, file their affidavits on of admission and denial of documents, the scope of controversy, at least so far as the evidence is concerned, is narrowed down. So then the court can proceed on that basis. So that is the only departure. Otherwise, the procedure for evidence per se remains the same.
Sure. I think I'm sure the students got an idea there. Now that see most of the audience here are students who are studying the CS course. They may be just studying CS or they may be doing law along with CS. And there's a high chance that most of them would work in a corporate. So as an advocate, and on just now you said that most of it is depending on the records and papers, contracts, agreements, and end of the day it's on the records. Can you tell us what is the role of the person in the corporate? More or less, very often it will be the company secretary who will be assisting and coordinating with the lawyer's office. What is their role and how important is it when it comes to the dispute?
Yeah, see, I'm just, not generalizing, or this shouldn't be a reflection of anybody's, performance as a CS or as a legal officer in a company. But their role actually starts, should start ideally much before the matter gets into a dispute or the matter goes to court.
Exactly.
They have to have, such a role. They, in fact, have an important role to play, no doubt. Their role should not start only when the matter is required to be filed in court or anything like that. They in fact have to be hands on and advise people handling these matters, contracts or any transaction with any third party, to maintain proper correspondence. Over the years, we've seen that cases are lost because so many things are not put on record. So that's really important. They need to advise their people who deal with, say, contractors or some vendors, to put things on record and maintain proper correspondence. So they need to get acquainted with how court functions, how evidence is appreciated in court, and start from there. When it starts from, say, drafting an agreement. So the agreement has to be tightly drafted. And then if the transaction runs into some rough weather, then to go on record, with whatever you need to say. If there is a delay, for instance, by the vendor, you need to put it on record, because your claim for liquidated damages later may depend on whether or not you notified the other side.
Yeah.
So that is where they need to get involved.
Like
They
sending
need
the
to know
notice
how.
to the vendor or something like that.
Yes, maintaining regular correspondence basically.
Hmm.
And once it comes to interacting with lawyers, of course, they need to be just organized with all the documents, be acquainted with all the documents, and also involve all the people who they think are aware of the facts and can contribute in a way. So, for instance, now in an arbitration, which is, we filed, in fact, coincidentally, the affidavits today of our witness. So there, it's a money claim, no doubt. It's something which an accounts person can, depose, in respect of. But it also involves some technical issues, of manufacture, and some drawings had to be finalized, without which client couldn't, manufacture those products. So we also are examining a technical person, because he is competent to depose as to what impact the delay in sanctioning or approving the drawings had on the manufacturing process.
So here drawings you're referring to the physical drawings because for an account student drawings is the which drawings are you referring to here?
No, the technical drawings. Yeah,
Exactly.
yeah, not
Because
not not the accounts drawings. No, no.
yeah. Just want to clarify because
Yeah,
here they study that angle. That's why.
yeah.
Please go ahead.
No, I meant engineering drawings.
Correct. Exactly.
So
Exactly.
that is the design and all the specifications which are required for
Yes.
manufacture is what I was referring to. So essentially, that is what the legal officer also has to do. He should be in a position to advise, because he is the one who is going to be in touch with the external counsel. So he should be able to take a call proactively and effectively advise his management, to involve different people, to effectively lead evidence or whatever it is,
Yeah.
put across the case more effectively. So that's his role.
Yeah, I think just to draw attention of the viewers, this is the value add which we get when we talk to an expert or somebody who is looking at the practice side of things. Because see here, he was telling that you should start right from the drafting of the agreement. I mean, only if we have a well tight drafted agreement, which is tightly drafted, then everything else becomes easier. So when is a dispute? Only when there is a difference of opinion and each one means something else. But before that itself, there's a huge role for the in-house counsel or the company secretary or whoever is dealing with the corporate matters in the company, and that is a very big role. So going ahead, Nitin, can you please tell us in brief? I know it's a long procedure, but right from institution of the suit till you get the relief, the flow of events, that is, how does it work?
See, one other thing is which we didn't come to,
Sure.
was the amendment in 2018.
Correct. Correct.
Yeah, why I'm bringing this up is because that brought in another step to the whole process of commercial suit, which is the pre-institution mediation, right?
Okay.
So 2015, like I said, the only objective was speedy justice and whatnot. But 2018, the Parliament, proceeded on the basis of the doing business report.
Ease of
That's
doing
what
business.
ease of doing business, but they refer to it as doing business report in the
Okay.
objects and reasons.
Okay.
So one of they brought about two significant changes. One was bringing down the value, the specified value from 1 crore to 3 lakhs,
Hmm.
because they say that even quick settlement of smaller value disputes adds a lot, in terms of the public perception and a businessman's
Hmm.
perception of the effectiveness of your judiciary. And the
Okay.
second, which I think is quite important, is the pre-institution mediation. There were five things, five objects it sought to achieve, but these are the two most important things. So
Okay.
the first step when you institute a commercial suit is the pre-institution mediation. So that has been made mandatory now under Section 12A, which has been inserted. In every case, where unless where there is some urgent relief, interim relief which the party wants, then the mediation is mandatory. So that's basically it. So you need to file a form. It's a PIM form as it's called. All the legal services, the authorities under the Legal Services Authorities Act of 1987, they have been made in charge of this mediation. So if it comes to say Bangalore now, there's a district legal services authority who have in their panel trained mediators. So you file the form before them. Notice goes to the other side. It's nominal. The fee also is nominal, which is also an incentive. So you file the form for a fee of 1,000 rupees first, and then notice goes to the other side. It's a basic form where you need to only set out the brief facts of your case and what your claim is. So notice goes to the other side. They, call upon the respondent or the defendant to give his or her consent or no consent to the mediation. So once if they get a reply saying there is no consent, a non-starter report is issued, and you are, directed to go file a suit if you so wish. But if the defendant replies and says he consents to the mediation, then a mediator is appointed, and again there is a fee payable based on the, it's a slab sort of a thing, which is not, as high as it is for a suit.
So
So it is more reasonable. So any person would want to explore that option first. That not only gives the plaintiff, a chance to close his matter soon instead of going through the, process of a suit, and it also gives the defendant to come forward and say, look, I defaulted, I admit, but I am in some difficulty. I will pay you, 75% or whatever the parties may agree.
Mutually
And
agree.
sorry, you were saying about
Whatever they mutually agree.
whatever they mutually agree, and this whole, even if the mediation fails, eventually it is completely confidential. The mediator makes no notes, and nothing which goes on in the mediation is admissible in evidence against the party. Because some concessions may be made.
Okay.
The plaintiff may say, I have claimed 100, but I know I am entitled only to 70 or whatever. So that cannot be held against him if the matter goes to court later,
Yeah.
if the mediation fails. So there, if the parties say they reach an agreement, this is very important. The parties, if they reach an agreement, sign an agreement. A formal agreement is drawn up with the guidance of the mediator, and the parties sign off on it. That agreement by itself constitutes a decree of the court.
Hmm.
So the parties don't have to go trouble the court at all. Once that agreement is signed and the mediator, legal service authority puts their seal, that becomes the decree of the court. So if, let's say the agreement is for payment of money, and the defendant, he may have agreed, I'll pay you X amount after, say, 3 months, and he doesn't, you are not left remedialist. It is not like any other agreement which you have to again go to the court to enforce. Here you can straight away file execution proceedings and execute it as if it were a decree of the court. So that is a very significant amendment which the 2018 amendment
Yeah.
has brought.
But in your experience, like the percentage of cases which is resolved at the mediation stage, if you can give a ballpark figure, if you have any.
See, now it's too new, right?
Okay.
There are no such statistics still which have been put out, because
It's hardly
uh,
2, 3 years.
yeah, it came out in 2018, and last year we've lost the whole of last year.
Correct. Correct.
So we have not seen anything completed yet. All are ongoing,
Okay.
and some, of course, non-starter reports have been issued, but it is quite good. I have myself been in a few mediations, and they are all trained mediators, and they earnestly try to sort out the
Good.
matter. So that's all we can say as of now. But if you take an equivalent example of the Bangalore Mediation Center,
Yeah.
which the High Court established quite some time back, that is, of course, under Section 80 CPC, that goes to mediation, and the parties try. There, the success is quite high. I think it is more than 50% of the
Okay.
cases which get sorted out there. So
Good.
that's good. And anyway, coming to the next step of the matter,
Yeah.
if this is only, of course, if the mediation fails. If the mediation succeeds, the matter ends. So if the mediation fails, then it is left to the plaintiff whether he wants to pursue his claim. He will then have to file a suit, and he will have to lodge a plaint formally with the court registry with all his supporting documents. And then the court, at the first hearing, will issue summons to the respondent, to the defendant, and if there is any interim injunction he has sought ex parte, that will be considered, and otherwise the process is identical to a regular suit. Then the defendant comes on record and files his wakalat or appears in person, and he has now, under the Commercial Courts Act, an outer limit of 120 days to file his written statement. That now the Supreme Court, in I don't want to trouble your viewers with the case name and all that, citation and all that now.
No, no, please go ahead.
So I can give you the case name. I have it.
Yeah.
So that was, I think, Justice Rohinton Nariman's judgment in SCG Contracts India Private Limited, which was 2019-12 SCC 210. There, it's a departure from the judgments of the Supreme Court under the earlier regime. So now they've held that this 120 days period under the Commercial Courts Act to file a written statement is mandatory. Earlier, the Supreme Court had said it is directory and not mandatory, and therefore you can condone delay even subsequently after years together, and still, with a view to do complete justice and all that. But now the Supreme Court says, because the Commercial Courts Act also says, if a defendant does not file his written statement within the prescribed period of 120 days, he forfeits his right. So they have taken a clue from those words and held that it is mandatory. So if the defendant doesn't file it, he is deemed to have no defense, and the matter proceeds. But if he files his defense within the 120 days, Then, of course, the court has to frame issues like any other civil suit, and then the parties, have to file their affidavits of admission and denial of documents, and evidence is recorded, and thereafter, matter is set down for arguments, oral arguments. Here, one small departure again is that earlier in a regular civil suit, it was up to the court. The court had the discretion to direct a party to file written submissions. Here, it is mandatory for any party to file written submissions in advance in a
Okay.
commercial suit. So you need to file it in advance, mandatorily, and only after going through the written submissions, the court takes up the matter for oral arguments. So then, after arguments are heard, of course, it's the usual. It's posted for judgment. One thing I should point out here is, like in a, there is a concept under CPC of a summary suit under
Yes.
Order 37 CPC.
Correct.
Here there is a slight departure. Of course, in my view, this may give very wide powers to any commercial court. So here, Order 30, there is an Order 8A, which provides for summary judgments in a commercial suit. So there are grounds, which the Act itself lays down. It says the court may give a summary judgment against a plaintiff or defendant on a claim if it considers that the plaintiff has no real prospect of succeeding on the claim, or the defendant has no real prospect of successfully defending the claim, as the case may be, and there is no other compelling reason why the claim should not be disposed of before recording of oral evidence. So, again, this is somewhat in the nature of proceedings for rejection of plaint under Order 7 Rule 11 CPC. So here the court, at first blush, before going into evidence, any party may call upon the court, or the court may on its own, go into the question whether there is actually a case made out, or it is, just a frivolous case, or the defense set up by the defendant is just moonshine, as the courts have held. Then, it gives unbridled powers to the court to directly proceed to judgment.
Yeah.
This, of course, we've not seen it till now being done. But the practical, side of it in terms of time is, a hearing on whether or not a summary judgment would be warranted itself may go on for some time.
Correct.
And of course, if let's assume the court passes a summary judgment, or refuses to do it, then the aggrieved party goes in appeal before the High Court, and that itself may go off on a tangent. And then if eventually the higher court, the High Court or the Supreme Court says no, it was not a case for a summary judgment, the court ought to have gone into trial and sends it back. There is a chance that you may have already lost close to 3 or 5 years in this whole process, and so the very object of it may be defeated. So that's one thing that the courts will have to be wary of.
Okay. So in fact, before I go to the next question, as Nitin was speaking, one thing which I recollected was he was talking about the doing business report and all that. Parallelly, see, the government of India took the ease of doing business World Bank report very seriously, and all the parameters. In that, one of the criteria, apart from like registering a company, so many things, and there one of the criteria is enforcing contracts. And in enforcing contract, India was in the bottom 10 in the whole world. Maybe even in things like small shareholders democracy or protecting small shareholders, India was in the top 10, and it improved in things like registering a company, opening a business. But enforcing contracts, it was very, very bad. It was the bottom 10 of the entire world. That was also one of the reasons of this Commercial Codes Act, and that is why probably that 120 days mandatory what do you say, written statement. I think that was also one thing in the government's mind why that Supreme Court has given this order. I don't know. I'm just
No, it
assuming.
is. It is.
Yeah,
It
yeah,
is keeping in mind the object the Act seeks to achieve, which is
exactly.
speedy disposal of cases. Yes.
So yeah, so now the next question was like, what kind of reliefs do you get in the matters that you have handled? What kind of reliefs do the clients get?
No, in the sense, are you, is it what kind of judgments do commercial
Yeah, what
court
kind
pass?
of judgments?
No, it depends on the claims, and the nature of the claims or relief in each of those matters. In a money suit, the commercial court would, like in any other matter, direct the defendant to pay the money with interest. Or in, say, a joint venture, or a joint development agreement, if, say, the landowners are aggrieved that, look, I have, complied with all my obligations under the agreement, but yet the developer has not even applied for a plan sanction or commenced construction having got the plan sanction or whatever, so they may seek specific performance as against the developer. So the court may direct the developer to perform his obligations under the contract and specifically enforce it to that extent. Or let's say it is a partnership dispute, right? The partners have fallen out, and there are two factions, which makes it impractical or impossible for the firm to continue. So one of the partners or one faction of partners may seek dissolution of the firm and rendition of accounts from one set of people or partners who were in charge of the firm for some period. So the commercial court would then, if you have made out a case, order dissolution of the firm. So one more thing is lease. Commercial leases
Yes.
that, in fact, came for some consideration before the Supreme Court. So we had a matter, where, of course, this is on arbitrability, and still, leases executed for commercial purpose also would come within the ambit of the commercial code.
That's
So,
interesting.
yes, because even recently we had a matter where a lease deed, a dispute under a lease deed also went before a commercial court. So
Okay.
yeah, there are.
So the sky's the limit in terms of the scope and the how wide it can get. And also
Yeah.
now after the pecuniary jurisdiction has been reduced, virtually everything can be a commercial dispute. So that brings us to the last few questions. The first thing is in the last few questions, the first of the last few questions is what do you think are the future trends? Because end of the day, it's a very, very nascent and newborn baby, you can say, in terms of the law and also the amendment coming into picture. And after that, we lost 1 year with COVID and all that. As a practicing advocate, what are your predictions of the future of this law?
See, the intentions are good, and if it is put to proper use, then of course it will result in quicker disposal of cases. In this connection, the High Court has issued a circular or directions to every commercial court here to conclude or dispose every matter within an outer limit of 500 days. That's roughly what 1.5 years. That's of course not being put to implemented as of now, but it depends on various factors. The act on paper may have good intentions and may actually result in quicker disposal of cases, but the most the significant impediment our courts face is lack of infrastructure.
Yeah.
So I don't want to be, critical of judges or anything like that. But you know, every judge, every human being has his own limitations, and a bad infrastructure or an insufficient infrastructure doesn't help the cause. So that's one thing. And like I said earlier itself, the number of commercial courts now compared to the number of commercial cases or cases which have now become commercial cases is highly disproportionate. So now if I could make it simple, the number of ordinary civil courts now ought to have been commercial courts, and the commercial courts now ought to have been civil courts. That is the disproportionality in the situation now. So
Okay.
that's one thing, but we'll time will tell. And
Hmm.
the of course there are not too many judgments still in the field, but
Hmm.
as things proceed, I'm sure the parliament or the higher courts will take cognizance of the shortcomings and try to plug the leaks.
So it's definitely clear that it's a law which is evolving and like Nitin shared, that we hope that it evolves in the right direction with better infrastructure, more judges, more courts for these commercial matters. And you, as students of the company secretary course or corporate law, please make sure that you are well versed with the Commercial Courts Act, because this is something which is definitely here to stay. Not just that you should be aware of NCLT, which you are and you will, but please do, because there are many things which are connected. And also, you will be in your role as a CS having to execute matters and coordinate with the law officers. So finally, Nitin, can you please share your message to students with respect to, if they're interested in this field, how should they prepare themselves?
No, most company secretaries. I don't know whether it is by default or whether it is on account of their interest. But in many companies, the designation itself is company secretary and head legal or whatever it is. So
Correct.
most of them are from the law background,
Yeah.
and most of them end up doing both. End
Yes.
up doing company secretaryship or related work and also legal work by default. So they need to be aware of, like you said, not the Commercial Courts Act and also the CPC, and generally the procedure in court and what it takes to succeed in a claim or to defend a claim. So they need to know, like I said, they need to get involved in every matter. Which when there is, you can't get involved when you smell that there is a dispute. You need to be you need to be a little more proactive and avoid a situation where there can be a dispute. So you need to get involved at the contractual stage. Read up. Keep once even once you get employed or start practicing, you need to read up and be up to date with the latest position in law, and then you will have an idea of how to deal with
Mm.
things. So
So
that's
I
one thing.
think Nitin is one of the few lawyers who said that you make sure that it doesn't come all the way to the dispute, but he's telling it with the right intentions,
No, no.
because
I
usually.
in fact, very funny. But these days, we not these days, but King and Partridge, we are lawyers. We earn through people fighting. To put it bluntly, but we never ever encourage somebody to go to court. We try to persuade all our clients, to sort out matters, because it's not worth it. At the end of the day, it's not worth it. You after a long battle, you may succeed, but by the time you see the fruits of your judgment, it may be too late.
I
So
think.
always from a commercial perspective,
Mm.
particularly, businessmen don't want to be fighting in courts. They want to
Exactly.
sort out matters and move on. So we always advise them that court is not the way to go,
Mm.
and unless you are driven to litigation, please don't just to be vindictive or prove a point, please don't go to court. So
Exactly. So businessmen don't want to fight in court, which is very true. And as people who work in the corporate, like you being future company secretaries, all the audience here, so we would encourage you to read up, like Nitin said, and get well versed with the commercial code, CPC, and also the NCLT. So with that, we are ending this episode of the practical side. Thanks, Nitin. Thanks a lot for sparing your time and sharing your views on the Commercial Codes Act.
thanks, Alok. Nice. It was a pleasure being here. Yeah.
And we look forward to have you on future shows. I hope you'll spare some more time in the future.
No problem. No problem.
Sure. Thanks a lot, Nitin. So that was Nitin, advocate with King and Partridge. He's a partner there, and he shared his views on the practical side of the Commercial Codes Act. For more such episodes, please subscribe to Excel Academy. Thank you and all the best to you.